Judge Mashile, are you well today, this afternoon?
I am, especially after that short break. I welcomed it, actually.
Oh, Judge Mashile, how can you behave about the break before the questions start?
Yeah.
What will happen when the questions start? Okay, welcome. Thank you very much to you for availing yourself, Judge Mashile. We really appreciate it that you have availed yourself and you have come to this interview. Yesterday, we adopted criteria for the selection of candidates for judgeship. And in the document containing those criteria, we agreed that while on the one hand, the questioning can be robust, at the same time, as we question candidates, we will have due regard to the candidates' human dignity, will show respect and courtesy, and there is nobody here who is here to try and humiliate anybody or to treat them unfairly. I'm going to ask you some questions, Judge Mashile, and after I'm done, I will give the JP of the Mpumalanga division an opportunity to put questions to you, and after that it will be the minister, and after that the floor will be open to other commissioners. So we are going to start, but before I give the JP the opportunity, there's going to be a time when I will give you about 15 minutes to give you an opportunity to share with the commissioners what challenges you have identified in the division, Mpumalanga division, and how, if you were to be appointed as Judge President, you propose to deal with them in that division. You understand?
I do.
Thank you very much. Please tell us your qualifications, academic qualifications.
It's BA LLB.
Which you got from which universities?
With the University of the Witwatersrand.
Yes. Before you were appointed as a judge, you practiced for many years as an attorney, is that correct?
That's right.
Was it about 20 years that you practiced as an attorney?
Yeah, plus minus, yes.
Plus minus 20 years?
Yes.
Okay. And your practice, how diverse was your practice?
Fairly. Okay. You're not saying I must mention what we did, but just it was fairly diverse.
Yes, in terms of different branches of law, that's what I'm talking about.
Yes.
It was fairly diverse.
Yes.
You had commercial law as well.
We had commercial law in the sense of commercial litigation.
Yeah.
The bank work, yes.
Yes, okay. And you were then appointed to the High Court. When were you appointed to the High Court?
2013, July.
So in 3 months' time or so, you will finish 10 years as a judge of the High Court.
Correct.
Before you went to Mpumalanga, to the Mpumalanga division, you spent some time, didn't you, in Gauteng?
That's right.
Yes. And when did you go to Mpumalanga? Was it when it started, the new division was started?
Well, shortly, formally, or remember, we used to go on circuits.
Yes.
So I would go for a month, 2 in a year.
Yeah.
And ultimately, in 2019, I think it was, that's when I transferred to Mpumalanga.
Yes.
And I think it became effective around October 2019.
Yes.
Yes.
Okay. And now you have been in Mpumalanga from 2019, is that correct?
Correct.
And if you compare the work at Mpumalanga and Gauteng, what is the difference in terms of the different types of work that one gets exposed to in those divisions?
Well, obviously, Gauteng, it's more assorted. Whereas in Mpumalanga, it's depending on where you are. Middleburg would be exposed to, for example, the mines. Mpumalanga would be your admin because of the seat of government. But essentially, you have almost everything. It's only volumes. So you would have, or there are there's certain work that is specific to areas like Mpumalanga, agriculture, servitudes, and other stuff. But when you talk variety, Gauteng has a more varied scope of work. I'm not sure whether I've answered your question. But in terms of volumes, the work is sufficient for the number of judges that are there. Gauteng has a whole lot, but it has a larger number of judges.
Are there about 7 judges in the Mpumalanga division?
9, I think.
9.
You've got the JP, the DJP, and 7, yes, judges. So if you exclude the 2, we are 7.
In the seniority, whereabout are you among the judges of the Mpumalanga division?
I would be the 3rd from the JP. Am I right? No, 4th. Sorry.
You are the 4th if you count from the top.
If you count from the top, yeah.
Yes, okay, all right. Now, I would like now to give you a chance to share with us what challenges the Mpumalanga division has that you have identified and how you would propose to deal with those challenges if you were to be appointed as judge president of the division.
Well, it's quite open-ended, but let me start here. Maybe accessibility, because of the size of Mpumalanga, unlike Gauteng, you can travel from the south to the north in probably an hour, not now with load shedding though, but in Mpumalanga it's quite massive. So you have the challenge that people travel for quite a distance to reach justice. For example, if you go to the southeast, it would be, say, the area of Mkhonto. They travel to, I think, New Brighton for a high court. That's about 120 to 130 kilometers. So you would, I can't remember, but I know that the JP was concerned at some point about that. But that's one area. And obviously, one way of solving that problem is to identify those areas that require circuit courts and raise it with the probably the office of the CJ to see whether one cannot establish circuit courts. Another one which is quite, it affects, it would be for disabled people, accessibility of the building to disabled people. There are ramps, but I see that for blind people, you don't have brailles, for example, at the door or doors. It's one area where you can make some changes. And I think to engage even with people to find out what the problems of people who use the court, the legal fraternity around, I know that they have complained about our directive, except for the Highveld. The Lowveld has not seriously engaged to say we have challenges. How do you assist us? But my belief is that if they were to engage, because these directives are made for the people around, so if they confront challenges, the only thing that they can do is to engage with us vigorously. And I think that's the little that I've identified, CJ. I don't have much.
Yes. Okay, so accessibility in terms of long distances that people travel to get to court.
Yes.
To accessibility in terms of buildings so that they are accessible to disabled people. And then 3 directives that have been issued that some people complain about. Is that right?
Or generally, people must find it easy to engage, because you find that people, instead of engaging, they would go to the media or they would go somewhere else, and the next thing you're surprised when you haven't been engaged on something.
So what would you do about that?
Well, encourage that kind of environment that where there is a problem, and I think it's already happening because there are various committees where they are supposed to be represented. But what I'm saying, people may not express or vent out at some of these committees that are meant precisely for that. So is to create that environment, to encourage them to engage.
There you are talking in particular about practitioners.
Practitioners, yes.
Yes.
Or the legal practitioners in general.
Yes. Those are problems that you have identified which exist at the moment. Are there some problems which existed when soon after the court has started but which are no longer there? Or were these always the problems or challenges that were there from the beginning?
Well, some have been resolved. Outside of that, obviously the court being new, you've got a lot of teething problems, infrastructure teething problems, roof leakages. That has been a major challenge. Something's not working. But infrastructure.
Are you saying there is also some problem with regard to infrastructure?
There is. The other day I was missed by some falling object from the top. So, and there was water leakage. For some reason it stopped. I hope they've resolved it, but as far as I know, it wasn't resolved. But there must have been water leaking in the ceiling. And the next thing just dropped on my table.
What is the state of case backlogs in the division? Do you know?
What, civil or criminal or
All.
generally?
All of them.
Civil, I think our case management, case flow management, I think that works for the division, I must say, since it was implemented. I mean, if your case is certified ready today, you can be sure that you will not wait for 3 months to be allocated a date. At most,
You won't wait for 3 months to be allocated a date?
a hearing date, yeah.
Does that mean you'll be allocated a date that falls within 3 months, or that means you'll be told of a date that falls outside of 3 months, but you will get the notification within 3 months?
Within, you'll be heard.
You'll be heard within 3 months?
Yeah.
So,
And,
so that suggests that there probably is not any serious backlog.
No, not insofar as civil is concerned.
Yes. Okay, thank you. Judge President, I give you the chance to put questions to the candidates.
Thank you very much, CJ. Judge Mashile, you appreciated the break that we had because of the problems which the Premier had. I understood you to be saying that you felt somehow intimidated and that helped you. Am I right?
Yes, yeah, you are correct, JP.
But I've seen that in your last interview in 2013, you were referred to as a lion or Dao. I had always thought that lions are not easily intimidated. Are you okay now?
I am fine, yes, I'm settled. Thank you.
Thank you so much. The post that you have applied for would require some sort of administrative expertise or knowledge. Do you agree with me?
I do.
You have been an attorney for almost like 20 years. Were you there as the owner of the firm of attorneys, or were you somehow working as a professional assistant?
Well, I started the company or the firm. Yeah, and until I left, I was the owner.
You were the owner.
Yes.
Now, by the time you left, how many staff did you have, and perhaps how many attorneys did you have, or candidate attorneys?
Well, there were four partners, and I was the fourth. So staff, we would talk about probably 20,
Yeah.
because we also had, maybe slightly more, but we also had a call center. So that took the numbers up. But on the just legal side, we would have been about 10 to 15.
Were you also playing a role in the administration of the practice?
Absolutely.
I'm deliberately asking you this question because after having been an attorney for almost like 20 years, I have discovered that that administrative experience comes very handy when you are a judge president. I just wanted to make that statement for now. Now, you came to the division by way of transfer that was mechanism created for Mpumalanga and Limpopo in terms of Section 50 of the Superior Courts Act. Am I right?
Yes, you are right.
Why did you elect to come down to Mpumalanga? I had always thought that it's good to live in the cities.
I think I was a bit tired. Another thing, I hail from Mpumalanga. My parents hail from there. I grew up in Alexandra. My parents lived here and had a house. So, in Pilgrim's Rest. So I always, during holidays, would go home and come back during school term. So I've always had one foot that side and another this side. So I think I was getting tired of bumping people around town. There aren't many people in Mpumalanga, unlike Gauteng.
Okay. Now, when you came to Mpumalanga in 2019, you were one of the most senior judges. It was the JP, then it was Judge Hueli, then it was yourself, and then it was the present DJP, am I right?
Yes.
Okay. Now, there are two seats of the division. That is the Mpumalanga division, the Mbombela, which is the main seat, and Middelburg, which is the local seat. And they are far apart by about 200 kilos. You're aware of that, am I right?
I am.
And as the JP, before the appointment of the DJP, you are aware that the most senior judge, that is Judge Khweli, left us, and I think towards the end of 2019, to act in the ACA, and she came back last year during the fourth term, am I right?
Yes.
And before the DJP was appointed in Middelburg, you were the most senior judge in Mbombela, that is the main seat, am I right?
Yes.
Yeah. Now, by now I'm sure you are aware of the volume of work regarding a person who is the JP, and in most of the times you would be the one who will stand for me if I'm not at the main seat.
Yes.
You also have the opportunity to actually allocate matters to some of the judges on my request.
I did.
Okay. And probably as you are allocating, you are checking your judges and the kind of matters that you needed to allocate to them, am I right?
Yes. That's very important, yeah.
Okay. Now, do you think that to a certain extent helped you in terms of the position that you are applying for?
Yeah, most certainly, because that's part of the duties of the JP.
Okay. Now, you will recall that the interviews for, the shortlisting for this position took place on the 30th of January. I think that was the case. And a day thereafter, I wrote an email to you and to the DJP after both of you were recommended, or when you were shortlisted, am I right?
Yes.
And the email reads as follows. Once again, allow me to say congratulations to you. I have been thinking what I can do as part of preparing you for the interviews without seeking to preempt what questions may be asked during the interviews in April. For this, I hereby extend an invitation to both of you to approach my office for information or briefing regarding the working of the office of the Judge President. Now, you availed yourself for that opportunity since the 1st of February, am I right?
I did, thank you. Yes.
And you came to know that in addition to allocate matters to the judges and also taking some of the most important matters and allocated them to yourself as a head of the court, you also discovered that there is a committee referred to as PEC, am I right?
Yes.
You have recently attended a meeting of the PEC, am I right?
Yes.
And you have been provided with the previous meeting, the previous minutes of those meetings. Am I right?
Yes, I have been.
Now, did you find that helpful in terms of what is happening at the PEC meetings?
Yes, and even from attending, I think I attended 2 of them, but yeah, that gave me a pretty good idea of what is going on.
You also, because you actually extended your hand to say, I want to know better about the working of the office of the judge president, you also became aware that there are other ceremonial functions which, as head of court, you need to attend in your own division or province.
Yes,
Amongst others is the invitation during SOPA, State of Province Address.
yes, yes, I was part of it.
You were also part of the judges who attended the State of the Province Address this year, am I right?
Yes, I was.
And we have actually emulated what is happening in Cape Town. In other words, we get properly roped together with the judiciary in the lower courts, the regional court president, the chief magistrate, and we go there with designated places and also a separate office so that we can run away from politicians during the attendance. Am I right?
Yes.
Okay. I'm sorry. Not really running away, but just not to create the impression that we are not separate. Now, during your interaction with the office of the judge president, you were also told about management meetings, which are held every month. That is between the head of court, the DJP, the director, and the court managers. Am I right?
Yes,
You also had the opportunity to attend some of these meetings.
I have.
And also you had previous meetings relating to these meetings.
Yes.
Did you find that to be helpful in terms of the position that you are applying for?
Well, yes, it's always helpful to attend them because one then gets an idea of what is coming or what will be coming if one is appointed. And it's in preparation, in fact. So, yes, I appreciate that I was given opportunity to attend those meetings.
You also discovered that there are registrars meetings with the JP every month as well. Am I right?
Yes,
And you also had the opportunity to attend some or one of these meetings.
correct.
Okay. And you also asked for the previous minutes of these meetings.
Yes,
Okay. Did you also have the opportunity to attend what is referred to as facility meetings?
I did.
The CJ was asking you earlier on about some of the challenges, and you mentioned some of those challenges which are connected to facility. Am I right?
Yes,
And you also had some minutes of the previous meeting relating to this, which meetings are also conducted every month. Am I right?
yes,
Okay. Did you find that helpful?
very.
And this would have included what is happening at the local city in Metlebek. Am I right?
Yes,
You are also aware that we intend to establish a circuit court at Mpumalanga, and probably in the course of this term, we might have the first case to be heard at Mpumalanga.
yes, I am aware.
And that is to bring the cost closer to the people, as you have indicated to the CJ. Am I right?
Yes,
Okay. You are aware that I have asked the DJP to have regular meetings, which should be referred to as a provincial judicial forum. That is the heads of court to come together to discuss challenges, especially taking into account the coordination functions of each court of each head of the High Court in relation to Section 8 of the Superior Courts Act. Am I right?
yes,
And that has been assigned to the DJP to deal with, and meetings have not been held in terms of you attending. Am I right?
correct.
Okay. Now, I'm also aware that you have submitted response to some of the issues which were raised by practitioners, and that you submitted, I think, last week, Thursday, am I right?
It was, yes, Thursday.
I must tell you, Judge Mashile, I was intrigued by how you concluded in that response. And I'm just going to refer you to some of what you actually said. Amongst others, you said this: complaints do not detract my suitability to be appointed as head of court. My commitment to my judicial duties demonstrate par excellence that I am suitable candidate. And I want to deal with this issue of par excellence. And I can assure you, Judge Mashile, when I allocated matters to the judges, I never doubted your ability to deal with any matter. And I would imagine when you speak about par excellence, you're talking in particular by the fact that you are blind. Am I right?
Yes.
Yes. And I can assure you that, in fact, when I allocate matters, I do not think of you in that context. And in fact, I think by virtue of the fact that you are the most, or amongst the most senior judges, I have always allocated matters to you without blinking and thinking about your blindness. Now, and I just wanted you to know that. And I also had the opportunity to sit with you as a full court. And the recent matter that we set together related to the REF matters. Do you remember that?
Yes.
I was the scribe. And I circulated a judgment which was almost the longest judgment I ever written. You were the first one to come back with your comments, almost like 3 days or 4 days thereafter. How did you manage that?
Well, I went through the judgment as quickly as I could and identify those areas where there was something wrong, or they were cosmetic. Yeah, I would say they were cosmetic, albeit that there was one or two things, but not so serious. Yes. How, I don't know whether you want me to go into how I read and so on.
We'll come to that.
Okay.
Cosmetic, I think you have been modest. It was not. I mean, you raised very important issues that in actual fact were included there. But here is your last statement in your response. And you are saying this: my appointment will not only be significant to our division, but to the Republic and continent as well. It will demonstrate that no barriers cannot be overcome. That's what you said in your response. Now, I have always been reluctant, and perhaps I did not have the courage to ask you this question. When did it start? How did it start? And how did you manage to be where you are today?
Yeah, I'll be brief. So how did I become blind?
Yes.
Yes.
Yes?
Well, my blindness was the result of an assault here in Alexandra.
When was that?
That was 1979.
At what age?
I was 16.
Okay, yes.
And from there, I think I stayed for 3 months in hospital. When they confirmed that there was nothing that could be done, I had to go for rehabilitation. And I lived with a very young brother, so he had some other businesses to attend to, as you can imagine. So I was left to myself, and he had to make sure that I was independent so that he can attend to other things. But I then went to St. John's Eye Hospital. They had a rehabilitation center. That's where I learned Braille, mobility, to walk and so on, cooking, cleaning, and so on. So I was fully rehabilitated there. And a year later, I went back to the same school, the same high school where I was when I went blind, which is Alexander High School. So went up to matric and then applied to vets. In the process, so when I completed matric, there's a family that took care of me, and they made sure that I went to university, and I got a bursary. So I did from 83 to 85, it was my BA, 86 to 88 LLB, and then
Record time?
Record time, yes. No, I did not delay. So thereafter, I served articles with Edward Nathan. It was Edward Nathan Friedland then. I think now it's called ENS. And shortly thereafter, I then, in 1991, I became what was referred to as a PA then, professional assistant. I worked for about 5 months, and I opened my own.
Yeah. But
And
yes,
in 1991.
Yes, fast forward. How did you manage this? Almost like you did not need what you did not have at that time. How did you manage this?
I did not have what?
How did you manage to achieve all of this?
Look, at university then, we obviously didn't have computers, but literally each lecturer would stand in front there and ask students to volunteer to read material onto a tape. So that's how I did it. Braille was useful when I was still in high school, but remember, I did not grow up using Braille, so it didn't come naturally to me. I could not read as quickly.
Yeah.
So when I went to university, I had to switch over to listening. So students would, or fellow students would read material onto a tape, and I would read. And for typing for my answers, I used a typewriter.
Yeah.
Typing, but I could not read what I was typing. So there's one incident, I think I was just, the problems, for example, of typing what you can't read. I remember one day I was writing a paper.
Okay.
I wrote for 3 to 4 hours, and I was using a typewriter.
Oh.
At the end, when the invigilator came, I've put a stack of papers which I thought were my answers. They were empty.
Okay. And how do you currently manage to deal sometimes with voluminous matters before you? How do you manage that?
Well, I asked the parties to forward their papers to me electronically and in Word, if possible. If they don't, then someone must... I have a system where I convert PDF to Word, but that doesn't yield the best results always because depending on the print, it distorts the letters. So it's always preferable to have the parties to send the papers in Word to me. So that's how I do it. But invariably, the annexures to the papers are always in PDF, which is a hindrance to my preparation at times.
CJ, thank you so much.
Are you done, JP?
I am done, but just for perhaps just one last thing. As a JP, you have got a lot of administrative work to do, and almost like on a daily basis, you'll be getting letters from the practitioners. How are you going to deal with that if you are appointed?
Well, they email, and look, what happens is whatever you read from your computer, I have a voice synthesized software computer which reads everything that is on the screen. It's called JAWS, it's a screen reader. So everything that you see on the screen, a voice, in my case, reads.
If I send you an email now and you open that, there will be that voice, you'll know exactly what I'm saying in the email, because I've always been surprised. 5 minutes, 10 minutes down the line, you respond. Is that what is happening?
That's what happens, yeah.
Oh, okay. Thank you, CJ.
Thank you, JP. Premier, I now give you the opportunity.
Thank you very much, Chief Justice, and good afternoon to Judge Mashile.
Good afternoon, Premier.
My first question, Judge, it's with regards to Section 174, subsection 2 of the Constitution, which places an obligation upon judicial officers to ensure that the judiciary is transformed and reflect the racial and gender dynamics of our country. Now, can you tell us, in your time in the judiciary, how have you contributed to the transformation of the judiciary? And if you were to be appointed in this position, how would you advance the need to transform the judiciary?
I think that effort is already there, not to me as an individual in particular. When you talk about gender transformation, that's a song that is sung every day. And I think we are very close to achieving that gender parity on the bench. I think if you look at our division, the number is almost balanced. You have 3 female judges in Middelburg and 1 male. And in Mbombela, you have 1 and 4. Let me see. So, yes, it balances out. We have 4 females and about 5 men. So, and that's, I think, the picture that you get nationally. Because I think at the moment we must be around 43 to 45% female and the balance male. I'm not sure whether that answers your question.
Yeah, Judge, you are saying it's almost like a broken record. And of course, transformation, in my view, it's something that happens almost on daily basis, or rather it should happen on daily basis. Having been there for quite some time, and you have clearly articulated what has been contained up to thus far in terms of the 2 divisions that we are having. Are there any deficiencies perhaps that you may have identified as an individual who might be seized with the responsibility to lead our High Court? What would you do to ensure that we take the record to greater heights, if not maintain the status quo, the current status quo? What would you do?
Well, is to encourage our female colleagues, or shall I say, practitioners, female practitioners, to take up the opportunity. There are seminars whose aim is to train aspirant judges. But they are not discriminatory. But I know that Judge Mashile, for example, has been appointed by or requested by Sajay to train specifically aspirant female judges. So something is being done. We are not sitting back and hoping that something will happen without us actively participating. What else? Oh, yeah. Even the people who are invited to our division, I think if you were to take statistics, you'll find that more female have been invited to act, or the number is higher than those of males. So that way, we hope to have more people or a larger pool to draw from when the moment comes. And that's a pattern that one is going to try and encourage, or encourage, not even try, to continue with that what's the word? My God. Yeah, but that's what we'll try and persist with. It's already happening, and we'll continue to do so. Thank you.
No, thank you very much. My next question would be, and I want to borrow from where Judge President has left off with regards to your excellent turnaround time. I've been going through the packs that we have received from JSC. Now, what I could establish from that is that emanating from 2022, you have about 12 reserved judgments. Now, having said that earlier on that you seem to have quite a good, excellent turnaround time. Looking at the judgments that you still have in your desk, does that not disadvantage the people whom you are supposed to service? And what measures would you put in place to make sure that you overcome the backlog of your reserved judgments?
Yes. It certainly does. But unfortunately, this occurs because I am attending to the service of the nation in other capacities. And I'm not saying I want to neglect the other part, but already I am doing that, attending to those reserved judgments. And as I say, of what I had mentioned last year when I applied, I'm left with 3. And of course, there are other judgments that have since been reserved. But that's the life of a judge. Yeah. But also, I think I've tried to explain how this had come about. It's not something that has always been there. It's something that slowly crept up, I think, crept up when I was appointed to the NCCS, which I think it was inundated with quite a lot of work when I joined, and everyone was complaining. So, and I do mention there that we had to put time aside to attend to that. That has since been cleared, and that should improve the number of, or the quality of my work, or the number of judgments that I've reserved in my daily, during my daily work. So that's how I intend doing it. In fact, that will resolve itself. And of course, I'm working quite hard on it.
Thank you very much, Judge Mashile. Thank you very much, Chief Justice. I have no further questions.
Thank you, Premier. Minister?
Thank you very much, CJ. Judge Mashile, good afternoon.
Good afternoon, Minister.
Yes, given that this is a leadership position, what is your leadership philosophy, and how are you going to apply it to this position if appointed?
Well, I think the idea, well, fortunately, one will be leading a group of judges. It's not anyone. So one would say you start on the understanding that these are people who respect their duties. And my responsibility remains, of course, to leading the people. Well, the philosophy is I can't run ahead alone. Okay. I'm not sure whether it's okay. Not.
I think you can continue. Yeah, I think you can continue. Oh, we can't hear you. Can you hear us?
And I can hear you very well.
Yes, okay. No, you can continue. That was load shedding, but we are able to continue. You may continue.
Well, Minister, you said, what is my philosophy? Well, I believe in running ahead, but still not leaving people behind. Because you might find yourself being ahead alone. By that, I mean that whatever decision one comes up with, one must run it through one's colleagues to see that you are not running alone. And that way, decisions become popular amongst your colleagues. And that's what I believe.
Thank you, CJ.
Thank you, Minister. Commissioner Mpumalanga.
Thank you, Chief Justice. Good afternoon, Judge Mashile.
Good afternoon.
Just one question from my side. In responding to the concern about the reserve judgments, one of the issues that you alluded to was that the reserve judgments could partly be attributed to the cautious approach in dealing with the ref matters, and also your responsibilities as the chair of the NCS. You have elaborated on the NCCS but you have said nothing about the cautious approach in dealing with the road accident fund. Can you just elaborate on that? Because it will be quite important to understand why the word of caution when you deal with the RAF, thus leading to the number of your reserve judgments. Thank you, Chief Justice.
Thank you. I think I have touched on the point, but thank you for giving me the opportunity to go further. What happens, or what happened when RAF stopped defending? Practitioners bombarded us with what they refer to as default judgment, not in the conventional sense, but default judgments nonetheless, in the sense that they would say, look, the other party is not defending. Therefore, we don't have to lead witnesses. We do not really have to prove. Once they say an accident occurred, you must accept that an accident occurred. I have a police report. Once a person says I was in hospital, you must accept. Once an expert says I have seen this person, I'm a psychologist, this is what happened, and you can't question that. So my attitude has always been, but if you say an accident happened, I need to be convinced that indeed it happened, because we've seen very strange things happening. At times, an accident occurred, but the merits are not necessarily in favor of the plaintiff, or the RAF wants to settle where it shouldn't. So they don't really, you find that some things don't make sense. You read the reports, you find that there are discrepancies. There's a discrepancy between a psychologist and the actuary. Someone is progressed from stage this to that, and the actuary calculates based on the psychologists or a psychologist. But you obviously see that it doesn't make sense. You question, and you find that indeed it doesn't make sense. So you have to go back, read these papers properly, and write a judgment. You cannot just sign an order and say, I think an accident occurred. It has to be proved. And that's what I mean when I say I've been fairly cautious, and not necessarily with RAF matters generally. Probably I'm a bit sensitive because of my situation. Criticism, that no, we understand the poor guy is blind. That's why he couldn't. We didn't see this. So I tend to be more cautious than I believe other people, just to make sure that what I produce is correct. But that doesn't go very far, because I was only told late, very late, by a colleague, a senior colleague, who said, look, don't worry too much about whether you're right or not. Just write, as long as you believe that you're right. I'm not sure whether that makes sense.
It does. Thank you, Justice Mashile. Thank you, Chief Justice.
Thank you, Commissioner.
Chief Justice, can I follow up on that, please?
Yes,
on
yes,
that last
please,
question.
you may.
Good afternoon, Judge Mashile.
Good afternoon. Sorry, I don't know the surname.
It's Baloyi.
Yes, Ms. Malohi.
Yes. Judge Mashile, your explanation for the delays in delivering judgments, it seems to me that they remain constant. So you continue to be cautious, as I don't think there's anything wrong with that. You have this responsibility at the NCCS. It remains in place. You continue to sit as a judge, and yet you are tagging on. You want to tag on, or you will be taking on additional responsibility if you are appointed to this position. How do you? Is there any way you give comfort, given all of this, that you give comfort that these complaints about delayed judgment will not be a recurring issue. Intuitively, it seems it should be a problem because you are taking on head of court responsibility if you are appointed.
Oh, absolutely. Look, if it happens, you cannot do this together with the work that I do at the NCCS. That's just, the load is too much. The minister will tell you, he knows. But if I'm appointed as a JP, I cannot continue as a chairperson of the NCCS.
Thank you.
Thank
you, CJ.
Does that mean you will resign?
Well, yes, but I didn't want the minister to hear that during this interview. But that's what it means. I should, just to be honest, to make sure that I do justice to the appointment. You cannot carry both responsibilities and
Yes.
still do well. Yes. Thank you.
Thank you. Commissioner Nyambi.
Thank you, CJ. Afternoon, Judge Mashile.
Good afternoon, Commissioner Nyambe.
It's one question from my side. As this is a leadership position, and you are going to be the helm of the High Court in Mpumalanga, probably if you can share with the Commission your understanding of good attributes of a JP, and mainly focus on those two that you think you possess that can come handy and assist you if you can be given the opportunity to lead that division.
Well, and this is something that I said, I think, in 2013. If you ask me, well, I've seen quite different worlds. I was one-sighted, I'm now blind. So I'm supposed to understand both sides. I lived in townships, I live in a suburb. So somewhat, I'm exposed to both cultures. And I've been in leadership positions before. I've delivered in those leadership positions. The NCCS, the minister, I'm sure, can attest to this. I mean, I was the head of a firm of attorneys for quite a while. I was the chairperson of the Pilgrims Rest Development Forum. We delivered. We did get the land back to the community. So, yes. I think that record speaks for itself.
Thank you, Judge Mashile. Thank you, CJ.
Thank you.
Thank you, Commissioner. Commissioner Marumwaha.
Thank you very much, CJ. Good afternoon, Judge Mashile.
Good afternoon.
I have a question for you, and the question might be a little bit unfair, because I'm going to ask you based on a case that the judgment that you delivered when you were still at the Gauteng local division, or the Gauteng division, Johannesburg, in 2015, perhaps, and I understand that you may not remember the facts and all those kind of things, but I think there are some important things that are coming out from that case that I really want to debate with you. It is the Tutubala versus Road Accident Fund. I'm not sure if you remember that case.
I do.
Yes. In that case, the very last paragraph of that case, you said that the mother of the son should fail because she was unable to prove her indigency and that she ever received income from the deceased son. And I think you may have been right in relation to the order that you gave. And the question I want to ask you is a general one in relation to claiming for loss of support in the context of claims that are brought under the Road Accident Fund. The question I want to ask you is this: how does one determine duty of support in the context of claiming for loss of support in these Road Accident Fund cases? And how central is the question of indigency in those claims? But most importantly, is the approach that is followed in South Africa an approach that should be followed, particularly when the claims are brought by parents in respect of their deceased children who may have not ever supported them in any way or means? I'm not sure if my question is understandable.
It is. But look, can I carry on?
Yes, you may.
Okay. How should one approach indigency? But look, in the context of Tutubala, perhaps, let me just go there. She came, the plaintiff came to court saying, I don't have money, I am indigent. Yet, as you say, I was probably right. Given what the facts of that matter, I don't know whether it's, you referring to that case, I don't think it's in line with what you're asking. But if you want me to confine myself to that case, because simply she was earning more, she was getting money, and she was actually getting more than she needed per month. That's why I came to that conclusion. But generally, when coming to parents claiming loss of support from their children, that's, I think, recognized even by, I think there's a judgment by the judge who's now in the SCAs from Cape Town, Babu, anyway, I've forgotten the name, but that whether it's customary law or not, the test is indigency. If a person is unable to support oneself, you can't say, I'm not responsible for my parents. You are obliged customarily to support your parent. And even on the, shall I say, Western this thing, I'm not sure of the word though, but in Western societies, the same thing applies, and it should apply in customary law. But in not customary law, what's the word? Sorry, but kids do owe their parents a duty of support, as long as one can establish indigency, whether is customary or not, they owe a duty. That must be established, that there is or a need exists to support them.
Chief Justice, I'm aware of the agreement that we made, but the response made me wanna, with your indulgence, may I just follow up? Or
Okay, all right.
I'll try to keep it.
Yeah.
And that's where the issue is, Justice. And I think perhaps on the law you may be right, but I'm asking a broader question in relation to the law itself. Mm-hmm. Because when you look at the concept of duty of support, quite generally, and how one obtains that duty, for instance, between spouses is through marriage. Mother to child is through birth. But it becomes quite a
different sort of consideration when a parent is actually claiming on the basis of duty of support from a child who has never supported them in any way. So the question that I'm asking is a broader question, that should we still have indigency in the true sense of the word as the test for you to be able to claim for loss of support under those circumstances? Because in any event, what you are claiming for is loss of support for the purposes of the money that would be available due to the accident, because we don't know what would have happened in the future. That's where the question is actually located.
Well, unfortunately, I'm a creature of, I fit somewhere on the ladder hierarchy. So that's what the courts above me say. And that's what I'm using. I think as a general proposition, yes. As you know, customary law would actually probably relax the indigency standard. Because at some point, and I think there has been attempt to lessen the impact. Because remember, indigency means that you can barely make it. And it's what is the word? They say the basic necessities of life. Now that's very low. If you don't have that, then you qualify. But it has to be applied in context. For example, a person who was getting living on 50,000 per month, if that person is down to 5,000, he's probably indigent. A person who was living on 100,000 per month, once he's down to 20,000, he's indigent. So, because he cannot measure up, and there are cases to support that approach.
Thank you, Chief Justice. I will leave it here.
Thank you, Prof. Commissioner Makwanishe.
Thank you very much, Chief Justice. Good afternoon, Judge Mashile.
Good afternoon. I didn't catch your name. You said
Commissioner Makwanishe.
Commissioner Makwanishe, yes, good afternoon.
Yes.
Thank you very much. No, I also have one question. As a head of the court in Mpumalanga, from time to time you'll be required to deal with issues of change management. So how will you manage the change management process from what you found to what you desire?
Well, I'm not sure whether there are things that should be changed at this stage. But if those were to come up, certainly I will attend to improving them, changing, if necessary. But so far, I don't think there is anything. But I'm not going to, or I'm not, you see, you've got people who, when they walk into an environment, they turn everything upside down and put in something new. Even if whatever you found works, if it doesn't work, then there is a need to turn everything upside down and come up with a new strategy. But so far, I think I am happy, probably because I've been part of the process of making what is there work.
Are you done, Commissioner?
Thank you, Chief Justice.
Thank you. Commissioner Shabangu Mdawe.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner Mdawe.
When you were talking about the challenges of the division, you mentioned that legal practitioners are complaining about directives, and when the CJ asks you as to what is it that you think you can do to change this, you indicated that they do not engage. So this is it's a long challenge that has been there for quite some time. And as a new judge president, what is it exactly that is different that you can do just to deal with this challenge or this problem that is in that division?
I assume that you're talking about the practice directives
Yes.
or other things.
The court directives.
Yes. No, look, I'm certainly not aware that, look, that problem of practice directives does not arise or or was there in the Highveld. And the legal practitioners in Middelburg, if you're not sure that I'm blind, now you know. Look, that problem was there in Middelburg. They had challenges. What they did was, I think they approached the JP or the DJP and said, let's talk about this thing because we have serious concerns. And all of us went to Middelburg and listened. We explained our position, where we come from. And I believe, probably that's what you'll hear from the DJP when she comes in, that practitioners in the Highveld are happier than they were before we went to them. Because there were things that they did not understand with the practice manual. What I have not found in the Lowveld, Bombela, is that no one has come to us and say, let's sit down. We have issues with 1, 2, 3. And we would have done exactly what we did. And that's I think my first thing. Because we saw how successful the Middelburg one was. When we came back, I think we discussed with the JP that, look, we need to engage these people, the practitioners in Bombela. And I think that process is still there. What I think the JP has been doing is to conduct as people come to court, he would take his time to explain how the directives, the rules fit in with the norms and standards. Now, but a proper way beyond that would be to have a larger gathering with everyone around Mbombela, White River, Barberton, and so on. Let's engage on this thing. And ultimately, those directives are meant to serve the people of the province. So it is that document. It is not the document of the division as such. But just remember that they are there to make sure that there's a smooth running of matters in that division. And so far, I think it is successful. There might be 1 or 2 issues, and if you do have, we are open. We say, come, let's engage. Maybe the way you approach those directives, it's incorrect. And for as long as people do not understand why they are there, you'll never be able to, you'll always be dissatisfied. I'm not sure, that's the only thing that I can say about those. But I think there's nothing, I can't go beyond engaging each other. It might well be that we are wrong, and we need to be shown that you are wrong, or that we are wrong. So let's talk about it.
Thank you, CJ.
Thank you.
Thanks, Judge Mashile.
Thank you, Commissioner Mdawi.
Thank you.
A follow-up.
Commissioner Matolo Sepu.
Thank you.
1 second. I don't have anybody after that and would like, if possible, except for Commissioner Pillay.
Follow-up.
Okay, let me just do this first. Okay, Commissioner Matolo Sepu, you may proceed.
Thank you, Chief Justice. I just wanted to follow up on the issue of the directives. That is it. I just want to find out from. Okay, good afternoon, Judge Mashile. What I wanted to find out is it not perhaps better to consult before you do a directive instead of doing a directive, then consult after, and consult the profession after. Thank you.
So you say instead of, okay, maybe I should say this. It's never possible to have a gathering, drafting a document. Someone must come up with a document and then engage. And that's what I'm calling for. I'm saying there's the document. If one is unhappy with parts of it, don't go criticizing. Approach the people who came up with it and say, did you or do you realize that this is the impact that it is having instead of this? So, but I'm saying someone had to take the initiative to come up with a document. And the JP did, he engaged us, we engaged him, and this is what we have now. So if you think it's not, we think it delivers. If you think it's not, please, let's engage. And we can't come one by one. I think the organization, either the LPC or the Mbombela Tennis Association must organize it, or BLA or NADEL. But a larger forum involving everybody will be helpful.
Okay, thanks, Chief Justice.
Thank you. JP wishes to have a follow-up, and I think Justice Spencer also wishes. Mlambo JP first.
Thank you very much, Chief Justice. Tau, good afternoon.
Dinek, afternoon.
You know me. Thank you. On these directives issues, as an aspirant head of court, do you agree that you need the buy-in of the litigation public you want to lead in what you want to do?
Yeah, absolutely. And I think that's what I mean when, if you have regard to what I've written, I say, if it doesn't address, so it must grow up out of the traditions of that particular area, of the area in which the division is. So if it doesn't, you'll have people attacking the very document. So one must indeed have in mind what is happening in that area when you draft these.
Well, I'm asking this question as a follow-up because this directive issue features a lot in your candidature as well as the next candidate's candidature. And we've dealt with it in Gauteng. I've not heard you tell us how you'll ensure there's buy-in in these directives. We've seen a lot of criticism that's documented. I understand you to be defending the directives, yet you are aware that there's no buy-in from a certain quarter. I would like to hear what you will do if you are appointed to ensure that there is buy-in into these directives. Thank you, CJ.
Thank you. JP, maybe I'm not coming across very well. I'm saying those people who do not buy into it, make us aware. Let's come together and let's see where the problems are. They might well have a point. As they are, we think they serve the purpose. But maybe, insofar as they are concerned, it's not, either because they are incorrectly implemented, or their perception is wrong, or we believe it's working when it's not working. But so far, we believe that they are working. But the first thing that one should do is to engage with the legal fraternity, people who use those directives daily, because it affects them, or they affect them on a daily basis. So they can't keep quiet and complain without engaging us. I'm saying, let's talk about it. And I didn't mean to sound as though I'm defending. I'm saying, let's talk about what is eating you. What is it that is wrong? For example, I think the GCP did point out to one or two. They raised 3 paragraphs in the directives. And I did address those, that this is where we come from, just by way of example. But, so obviously there are many others where there is a lot of dissatisfaction. Let's talk about them. We never said we are drafting a document that is cast in stone.
Am I correct to simply summarize your response, Judge Mashile, by simply saying you haven't identified who the people are who may be unhappy about the directives, but as soon as you know, you will engage with them to hear their side of the story and see whether there is a need to amend the directives or withdraw them or do whatever that will be a solution out of those engagements?
Yes,
Yes.
I agree. In fact, I'm saying it should be a document for everyone. It's not for the court.
Yeah.
It's for the area. So it must be a document that is supported all round.
Yes, okay, all right. Judge President Lambo, you were
CJ?
going to be the next one.
CJ?
You did a follow-up.
Oh,
So I'm
yeah.
just mentioning you may be covered by your follow-up. Oh, okay, all right.
Thank you very much, Chief Justice. Tau, it's me again.
Yes.
The JP mentioned that he introduced you to the Provincial Enhancement Committee, PEC, Efficiency Enhancement Committee. Have you chaired one? Such committee meeting?
Have I?
Have you had the opportunity of chairing a PEEC meeting?
No, I haven't chaired, but I only attended.
You've only attended. And am I correct that that's the forum that brings together all the important stakeholders in the justice system of the province?
Yes, you are correct.
Thank you very much, CJ.
Thank you. Justice Spitzer, I forgot that you all wanted to follow up on the previous question. Please do.
Thank you, Chief Justice. Good afternoon, Judge Mashile.
Good afternoon, Justice Spencer.
Just a follow-up on this issue of directives. Don't you think, if you could clarify this for my benefit, don't you think that it was desirable before they were brought in, they were implemented, for you to engage the organized profession?
But you see now, look, as I say, remember, you're talking about what I am going to do, not what has happened. So I think the question rather is a bit unfair on me. I can't say what should have happened. I can say what will happen or should happen.
Let me put it this
Oh.
way for Justice Betzer. Please forgive me, Justice Betzer. What would be the proper way of handling it if you were the head of the court and you wanted to issue directives, Judge Mashile? If you are appointed as JP and you wanted to issue directives, how would you go about it?
Well, the first thing you identify the need, is there a need? And you come up with a directive, send it to the people involved, the stakeholders. This is, I've identified this problem, this is how I think it should be addressed. And you invite comments.
Okay.
That's how it would go about.
Okay, thank you. I think that has helped Justice Betzer. Commissioner Singh, I understand you have a question.
Yes, thank you very much, Chief Justice. Thank you. Good afternoon to you, Judge Mashile. It's Commissioner Singh here.
Commissioner Singh.
I'm on the virtual platform. I think, Judge, you will recall the Moyo versus Old Mutual matter that you presided over, and then the matter went on appeal subsequently. But you recused yourself from the second matter because there was an application for your recusal. Now, during that matter, there was allegedly an unsavory statement made about judges to the extent that, and I quote, a single individual who happens to wear a robe. That's what was said by the chairman of Old Mutual, and I know he later apologized. But I just want to know if one of your judges in your division find themselves in that position, what would you do to protect the integrity of a judge, judicial officer, and the judiciary at large? Thank you.
I'm sorry, I'm not sure whether I understand your what will I do to protect the integrity of the judge in that situation?
The judge and the judiciary at large in these kinds of situations when those kinds of statements are made. Although I want to emphasize that the statement was later withdrawn, because you must have felt terrible when it was made. Thank you.
Okay. Well, I would rather not talk about me, but generally what should happen. I don't think, but as you know, judges speak through their judgments. If that's how he felt, it's for, and I think he was reprimanded, or you expect the relevant organizations that have interest in a proper working legal system to defend judges. But it will not help for me to respond, or to have responded to that kind of I don't know what to call it, a criticism, but to respond to that kind of a statement. The judgment is there. If a person is unhappy, should be appealed, and which they ultimately did. So it was just unfortunate that it was the appeal was foreshadowed by those kind of statements. Or there was something that was said before they took the right this thing. You can't attack judges because you do not like what they've produced.
No, thank you. Just to follow up, I just would like to know, did you recuse yourself voluntarily, or was it because of the application that was made? Thank you.
There was an application that was made. There was, I can't remember the ins and outs of the recusal, but there was an application, and I found that there was merit in withdrawing or recusing myself.
Thank you very much, Judge Mashile. Thank you, Chief Justice.
Thank you.
Thank you very much. I have Commissioner Nochesi and Commissioner Pillay. I'm not aware whether on the virtual platform there is anybody else, but otherwise I would propose to end with these two. Okay, Commissioner Nochesi.
Thank you, Chief Justice. Good afternoon, Judge Mashile.
Yes, good afternoon, Commissioner Chesi.
Yeah, I was not going to ask, but there is difficulty I have. In relation to your answer about the reserve judgments, particularly the 3, and if I count from November, that would be December, January, February, March. It's almost 5 months. Do you accept that one of the responsibilities of the judge president is to monitor compliance and implementation of the norms and standards? That's one. Last question, which is built on this, is that if the JP of a division slip in these circumstances with the kind of the response you give, what can you say about that? Because judgment 3 months, 6 months is part of the norms and standards. The question of delivery of judgment, it's not just a by the way. You know. So I just wanted to be clear on this. That's my discomfort.
So, what is your discomfort precisely?
What I'm saying is the delivery of judgment
Yes.
is dealt within the norms and standards.
Yes.
Is set up their time frames. Within 3 months, the judgment must come if you are late. And you could even be charged for the late delivery of judgment.
Yes.
Now, in this instance, I'm looking on the 3 judgments that you say, because you say others have been delivered, but there are 3. And then this, from your form, it was filled in November.
Yes.
If you count from November up to now, you have almost more than 4 months, you know, from the date of reservation of that judgment. Is that not going towards the transgression of the norms and standards? And which would be your responsibility as the JP to see or to monitor its implementation and compliances?
Yes, okay. But
Maybe before the candidate responds, let me just say, I think the general thrust of your question, Commissioner Jesse, is correct. But the 3 months in the norms and standards, it's what we aspire to achieve as the judiciary. It doesn't become misconduct just because you are over 3 months. It becomes misconduct much later. So I just wanted to clarify that. But 3 months is what we aspire, we would like to achieve one day. Okay.
No, I accept that, Chief Justice. I accept that 3 months is a warning, and then beyond 3 months, but 6 months.
And in many cases, it is achieved.
But the JP, obviously, in 3 months, must start to find out from the judge, where is the judgment, what is happening? Because he implement, he monitor. That's what I'm talking about. That is the essence of my question.
Yes. Look, I'm aware of the seriousness of not delivering on time. But as I said, maybe there was lack of balancing on my side because of the other responsibilities. I have to work on that as soon as possible. That list must be cut down immediately. But unfortunately, that cannot happen. When I say cut down, obviously, if I relieve myself of the other duties, you will not see that there. And you can go back to when I was not a chairperson, when the responsibility was not as huge. I worked in Gauteng, where on any, if you are in opposed motion, you could reserve as much as 10 judgments, but you are able to work on them within time. I'm not saying there weren't other judgments that were somewhat late, but I'm saying at any one time, you would have judgments, And depending on how your the whole roster is structured, if, for example, you have you are in civil this week, next week you are in the following week you are in opposed motions, depending on the size of the role, you are obviously going to carry quite a lot. But all I'm saying, I'm aware of the seriousness of the situation. But at the moment, I've got another responsibility. There are people, there are lifers that the minister want considered. So I must also attend to that. But once I am relieved, I should be able to give my attention fully to that list.
Thank you, Chief Justice.
Thank you. Just a follow-up. I think the question behind the question, if I can put it that way, Judge Mashile, may be whether the delays in the handing down of judgments that are referred to in the documents have not sent a message to you to say you should consider stopping the other functions that seem to interfere with your core function.
Yes.
What do you say to that?
Yes, I think I wasn't going to serve beyond my. I've been appointed as chairperson for a term of 3 years, and this is the final year. But again, I didn't want to disorganize the department by just saying I'm dropping off. So that's where I come from.
But you are not going to disorganize them. You are not going to just drop them off. You'd give them notice, and they could always find somebody else.
Yes. No, my term is coming to an end, Chief Justice.
So no matter how much those responsibilities interfere with your core function, you won't resign. You'll wait until the end of the term? Not necessarily. Maybe it would have come to, it hadn't come to that stage, that point. But I'm sure I was going to consider it at some point. Yes, okay, all right. Commissioner. Do you feel strongly, Minister? Okay, yeah, okay. Minister?
Yeah, Judge Mashile, maybe for the benefit of the public, why do you think it's important for you to perform this function on the NCCS?
Well, as you remember, we deal with, this is the other side of the duty that we discharge as judges. There are offenders who must be considered lifers. I mean, that's what we do. We advise on, or we recommend to you who should be placed or not placed on parole. The importance is there's overcrowding, and there are just quite a lot of lifers in the system, I think it's important that they be considered and this thing. Hence, we embarked on this thing, on trying to reduce the amount of those files.
Commissioner Pillay, you are the last one.
Thank you, Chief Justice. Good afternoon, Judge Mashile.
Good afternoon, Commissioner Pillay.
Judge Mashile, just before I deal with some adverse comments, I must put to you that there's a bit of a startling feature of your application, and there may well be a very simple explanation for it, but just to tag on to the line of questioning raised by JP Mlambo around getting buy-in and support of the broader community within which the court operates. It was very striking that in your application there doesn't seem to be any support from any of the law bodies, and particularly with black leaders in the judiciary, you usually find support from the BLA, from NADEL, etc. And that's absent in your application. And in fact, your nomination comes from an individual and not from any organization. Perhaps you'd want to deal with that.
I don't know. I did not, look, I don't know how to deal with that one, quite honestly, why I wasn't nominated by one of the organizations. But with BLA, I think it was said that as an organization, they would not do that because, or they don't do it. Well, that's, I used to be a member of BLA, and did not want to come across as supporting, as a body, come across as supporting a particular individual, but rather the members, individual members can do so. In other words, the nomination must come from a member, not the organization. I don't know anything about NADEL because I'm not, yeah.
Sure. And apart from the question of who nominated you from the position, what do we make of the fact that there are no letters of support or no support from these organizations, from kind of law bodies in general, leaving aside the GCB who gives almost a kind of a strict assessment? What do we make of that fact?
Well, it left me staggered. That's all I can say. I'm also surprised, and I've been raising it as well, that I'm not sure why these bodies have not responded.
All right. Then can I just move on to the fact that, as you are aware, there are two objections to your application. The first objection comes from the Amalgamated Lawyers Association, and it's quite a kind of a compound complaint or objection. So if you just give me 2 seconds, I'm going to put to you the 4 features of the Amalgamated Lawyers Association complaint. And the first issue, and they really, they revolve around the application to strike one Mr. Maluleke from the role, who was an attorney. The first complaint is that you ignored an application for special leave to appeal to the SCA, and you proceeded to decide the main application despite that application. Now, as I understand and you've given us, and thank you for that, you've given us comprehensive written responses to the objections. And as I understand your explanation, it's that the application for special leave came a day after you had decided the matter.
Yes.
All right, so that's the first aspect of the ALA complaint. The second part of the complaint is that you disregarded the order made by Semenya AJP, that the postponement application brought by the applicant must be heard by judges in the main application, and that was you and Judge Ranchod. Now, as I understand your explanation, it's that, in fact, you followed the terms of that order because you duly heard the application for postponement and eventually dismissed the application for postponement.
Yes.
All right, there's a third aspect to the Amalgamated Lawyers Association objection, and that's that you failed to afford Mr. Maluleke the right to be heard. There's 2 aspects to this. The first is that you, according to them, you refused to allow him to file an answering affidavit. And secondly, that you proceeded to hear the application after hours, after court hours, and in circumstances where Mr. Maluleke had indicated that he had to excuse himself from the hearing in order to attend to his minor child who had taken ill. And the matter was adjourned, but a little while later, a few hours later, the matter resumed in his absence, and the matter was determined in his absence. And the ALA is raising the fact that infringed his right to be heard, his right to audi. Your response to that, Judge Mashile?
Well, the response is there under the document, but let me say this. Remember, that's a matter that came a long way 2016, although papers were, or the application was launched in 2017. All along, if you read that file, until this year, there was no answering affidavit. The matter was punctuated by interlocutory applications throughout. And as I say, according to us, those interlocutory applications were designed to come to the decision to which we ultimately came. Now, that, coupled with the reasons that were given for Mr. Maluleke not coming back to court, he said he asked to be excused between 5 and 6. We agreed. And around just before 6, he said, look, there's load shedding, I'm going to delay. And we said, sure, we'll extend until 6:30. That reason, load shedding, changes at about 6:15. It becomes, my child has taken ill. This is the very child that he just collected from school, taking home. The child was not sick until 6:15. And as I say, couple that with the delay that has been there since 2017, we thought we had to finalize this.
Can I just ask in relation to the former issue, and just in fairness to ALA and Mr. Maluleke, Judge Mashile, one of the issues raised is that at the stage when Mr. Maluleke sought to introduce his answering affidavit, that there really was no reason to prevent him from doing that because the matter was not urgent.
No, we did.
And obviously you could have coupled any order with a punitive cost order for any delay caused by the late admission of his answering affidavit.
No.
So that's the first leg of the complaint. The second is that it's inexplicable that the matter was heard until quite late hours of the evening, far beyond court hours, in circumstances where the matter was not urgent. And I think that's the nub of the complaint raised.
Well, and I do say why we had to do that. Okay. This is a person, according to the papers, who should not be on the roll of practicing advocates, according to the papers. This is a person who has been found guilty in a disciplinary inquiry. This is a person who, in his affidavit for application to become an advocate, said, no, I'm a fit and proper person. Did not report that he had a record, a disciplinary hearing record. Now, I don't know really what is it that, how we could have helped. It's not an easy matter to strike off somebody from the role, but we had to do it. I can't do more than that, or better than what I'm saying. And the question about urgency, it was urgent, because this person is not supposed to be there. And I wasn't going to be available the following day. And pure, obviously, the way we regarded the matter, we said, no, look, this matter has been here forever. And it must come to an end. And we looked at the facts, the background facts, and said, yes, it was supported. Our decision was, we could justify it, that we had to end it on that day. But that we went into the night, we had made it clear during the day that we would proceed into the night if necessary, because I wasn't available. I wasn't going to be available the following day.
All right.
That's all that I can say about that.
Judge Mashile, that leads me to the second, I'm going to call it cluster of objections. It's equally complex and it's a compound objection, and it comes from Mr. Leroux. It's quite a fact-intensive matter, but essentially, Mr. Leroux complained.
CJ, it's me here. Yeah, Julius.
Oh, yes, I'm sorry.
I thought we agreed. I really thought we agreed.
Yeah, no, she is dealing with objections, putting objections from law bodies to the candidate.
Yeah.
So she's different from all of us in terms of putting all the objections so that the candidate can deal with them.
So when we deal with objections, we can do that?
Well, I have specially asked her because sometimes if I leave it to everybody, some might fall through the cracks. So I've just said she must look for them so that we never have the situation where everyone thought so-and-so would deal with it and then nobody deals with it and the candidate leaves.
Okay.
So that's the only thing. So it's not her questions, just the objections for all of us.
Okay.
Yeah.
These are the questions of the Chief Justice.
Yes. She helps me also so that I don't have to look at too many things. Yeah. Okay. Okay.
Thank you, Chief Justice. And Mr. Malema, I'll be brief. Commissioner Malema, I'll be brief. It's the objections that emanate from Mr. Leroux, and it relates to quite a kind of a complex series of applications that come before your court, and it stems from the spoliation application, and your first handling of the spoliation application on the 22nd of December. Now, Mr. Leroux has raised the complaint that you gave the order that you gave on the 22nd of December, notwithstanding the fact that in his view, he had obtained a favorable order from, at that time, Acting Judge Shabangu Ndawe in relation to the spoliation. Now, I've read your response. I just want to put your response on the record so that it's clear and you can confirm whether that's the case. That in fact what Acting Judge Shabangu Ndawe had done was granted a rule nisi, and that what the respondent had done was anticipate the return day. And you heard the matter on the return day. What you were dealing with was the return day of the spoliation and a reconsideration of her order. Am I correct? That's your explanation?
Yes.
And that's
Was
how...
that a yes?
Yes, so you say, so just repeat that. So it came back to me, it was a rule nisi, it was an anticipated rule nisi.
That's correct, yes. Yeah, and that's how it came back to you. I think the complaint raised by Mr. Leroux, and he's given the JSC an entire bundle of documents, and I'm trying to extract the relevant portions from all of those documents. The complaint was really, his first complaint was that you granted an order in the face of a judgment already handed down in his favor. And I think the real issue is technically you were merely faced with an anticipation of the rule nisi.
No, it couldn't have been a judgment. That's why it's a rule nisi.
Yes, no.
There was a return date which was anticipated. So
yes.
It had to be either discharged or not.
All right, and then when you do reconsider the matter on the 22nd of December 2020, you do it in relation to the fact that there are 9 portions of land. In relation to 8 of the portions, you find that there was that the applicant was not in undisturbed possession, and in relation to 1 of the portions, that's the last portion, 39, you find that he was, Mr. Leroux was unlawfully dispossessed.
Yes.
And you restore possession. And that's the end of the spoliation application at that stage.
Yes.
Now, what happens is that a new application is brought by the respondent, who then becomes the applicant in the new application, for the eviction of Mr. Leroux from portion 39. But that application comes on the unopposed roll. Now, you grant the application for Mr. Leroux's eviction on an unopposed basis, on the 12th of April 2021.
Yes.
And the complaint raised by Mr. Leroux is that that was improper, given the history of the matter, and the fact that, according to him, he had filed a Rule 30 and a Rule 30A notice a few days before you had granted judgment.
Yeah. Yeah. Unfortunately, Mr. Leroux, as I say, that Rule 30 was improper in the sense that I just don't know what he was trying to do, but let me just put this into perspective. They were not successful on portion 39. They came back to court. They served that eviction notice on him. Yeah, they did. So ultimately, it came to court. I don't know what is wrong. I'm struggling. They came to court on the 12th. I looked at the application. I then granted the order. I don't know what is wrong with that, because they were entitled to it.
The penultimate complaint by Mr. Leroux is that he asks for reasons for your order granted on an unopposed basis. And that there has been that you haven't complied with that request for reasons.
Yeah, but you see, Mr. Leroux is also, as I explained there, that he's quite prolific in writing. He doesn't give you one thing. He gives you a heap of documents. And in the midst of all that, I probably missed the reasons, and until now, that I haven't given him. But that didn't stop him from appealing.
All right, and then the final complaint raised by Mr. Leroux is that he was quite shocked to see that you were allocated another one of his matters on the 17th of November 2022. But I think you've clarified that that's an error on his part, that you were not, it wasn't meant for you. I mean, you were not set down to hear the matter on the 17th of November 2022. I think it was another judge, rule officer, who was meant to hear it.
Was never, no, Judge Rule Officer, I think, is involved in that matter. If I recall, yes, it involved Judge Rule Officer. That's why I said I couldn't have, none of us in that division would have heard that matter, because Judge Rule Officer has been acting. You will recall that he's like a permanent acting judge because there's a challenge about his appointment. So he's a colleague. No one can do that matter. So anyone who does it will have to come from outside.
Thank you, Chief Justice. I've tried to distill a very complex set of
Yes.
documents that were given to us, but I think that's the essence of the complaints.
No, thank you very much. I think you have done a very good job, because those big bundles from Leroux must have been. I think we have come to the end. We have taken quite long. I think I must thank you, Judge Mashile, for making yourself available. You are now excused.
Thank you very much.